Welcome to Asst College of Arts and Commerce. This is Asst Edupedia. Myself, Assistant Professor Sunil Shah. Today, I will be covering up the topic called Article of Association, which is there in the subject called Business Law, and this particular topic is covered up in SYBAF SEM 4 as well as in SYBCom SEM 4. Students, as you are aware, when the company has been incorporated, we need to have a necessary certificate, that is called certificate of incorporation and certificate of commencement of business. For the company to be incorporated, we need to submit to the ROC, that is Memorandum of Association and Article of Association. As you are aware, in Memorandum of Association there are 6 clauses, that is called capital clause, loan clause, object clause, the subscription clause and the capital clause. Whereas in this particular video, I would be covering up the main emphasis, that would be internal rules and regulation of the company, that is called Article of Association. As you are aware, the Article of Association of the company contains the rules and regulation relating to the management of its internal affairs. So how the company should perform, the way in which the company should act would be all mentioned in the Article of Association and has to be submitted to the ROC. It defines the rights, powers and the duties of the management. Clearly, it is an internal document. Next one, if the Article of Association should contain anything which is against the memorandum, won't be applicable, or it should not be against the company's policies or against the Companies Act 2013. A public company limited by share may register its own article of association, whereas a company limited by guarantee without having a share capital may file its own article. As you are aware, this particular word, own articles, that is, they have to form their own rules and regulation, and that particular rules and regulation has to be submitted to the ROC before the incorporation of the company. What are the formalities to be completed in connection with the Article of Association is that all the Article of Association, the points should be printed before the draft is being made. The draft has to be passed by the promoters or the directors. They should resolve that these particular articles are proper. After submitting to the ROC, when the ROC approves, and after getting the rough draft approval, it should be printed. This Article of Association should be divided into paragraphs and should be numbered consecutively. It should be signed by each and every signatory whose name is been subscribed to the memorandum or whose name is been registered with the ROC. It should be signed by each signatory of the memorandum in the presence of at least one of the attesting witness. The articles of the company must contain the following restriction. It should restrict the right to transfer the shares. So, related to the transfer of shares or transmission of the shares, this particular right has to be restricted and has to be mentioned into the articles. It should also limit to the number of members, should be 50, that has to be mentioned in the articles. It should prohibit any invitation to the public to subscribe for any shares or its debentures of the company or any type of public deposit. Coming to the content of Article of Association, what should be there? It should adopt the preliminary contract. In the Article of Association, it should mention that all the preliminary contract has to be adopted. The number and the value of the shares should be mentioned. The way in which the allotment of the shares has to be done has to be also been specifically mentioned. Calls on the share has to be mentioned, when the calls should be made to the particular person who had applied for the shares. Transfer of the shares, the procedure in which the transfer of the shares can be done, who would be the share register, who would be the underwriters, that has to be also mentioned into the Article of Association. The method in the forfeiture of the shares, if there is unpaid amount of money which is not been paid by the person who had applied for the shares, in spite of the several calls which has been given by the company, and if the particular investor doesn't pay the amount, the balance amount, the method in which the forfeiture of the shares has to be done has to be also been mentioned. It also should mention the way in which the shares has to be reissued, how the surrender of the shares should be done, how the bonus share has to be issued, or how the sweat equity shares has to be issued has also to be mentioned in the Article of Association. There should be also the particular format in which the alteration of the share capital has to be done. Also related to the format of the share certificate, there should be also the points which to be mentioned in the article of association should be the conversion of the shares into the stocks, the meetings, the types of the meeting, the process in which the meeting has to be conducted, the proceedings of the meeting, how should be concluded, the minutes of the meeting, how it should be recorded. It should be either in the digital form or in the manual form, has to be also mentioned in the article of association. The person who will be coming for the proxy for voting has to be mentioned. Who are the person who are eligible to vote during the voting session during the AGM? Who are the person who could be eligible on behalf of the other shareholder? That particular proxies definition has to be mentioned in the article of association. The appointment and the remuneration of the director, how much amount of salary, how much amount of remuneration, the process of appointment, the process of termination, removal, suspension, the borrowing power of the directors has to be also mentioned in the article of association. The dividend and the reserve account, the audit procedure and the winding up procedure also should be mentioned into the article of association. The article of association should also approve the type of seal the company would be using in future. Coming to the main difference between the two important documents, that is MOA and AOA. As you are aware, the MOA is called the charter of the company, whereas AOA refers to the internal rules and regulation. The MOA contains the object and power of the company, whereas internal rules and regulation, the bylaws for carrying out the company's object, is to be mentioned in AOA. The relation between the company and the outside world should be mentioned in MOA, whereas the relation within the company and its member is mentioned in AOA. The status is that the MOA, the Memorandum of Association, is a supreme document and subordinate to MOA is AOA. Please remember, the MOA and AOA has to be as per the guidelines which has been given by the Companies Act 2013. Related to the alteration, MOA cannot be altered, whereas AOA, the alteration is possible with the help of resolution. As you are aware, when the alteration is been done for the article of association, it should be done only through special resolution and it should be passed during AGM. The legal effect is that MOA cannot be ratified, whereas AOA, the alteration can be ratified. The companies which may have own articles shall have private companies limited by shares, the companies limited by guarantee, and unlimited companies can also have articles, own articles. Binding force of memorandum and articles is that it should be binding to the company, to a member, member to a company, member to member, and no foundation to the outsiders. So outsiders are not bounded by the articles of association. The forms, coming to that, section 30 deals with that. Section 30 of the Companies Act deals with the forms and signature which to be submitted to the ROC. The article proposed to be registered must be printed and divided into paragraphs. Each paragraph must contain at least one regulation and numbered consequently. Each subscriber to the memorandum should sign the document and in presence of at least one witness, both of them adding to their address, and the occupation is mandatory, supported with PAN card and the address proof and the birth proof. Alteration, coming to the alteration of the articles, every company has a clear power to alter its article of association by special resolution, as I mentioned in my earlier statement. It is a statutory power given by the articles, given by the section 31 of the Companies Act. The power of alteration as conferred by section 31 is almost absolute, and it is subject to only two restrictions. That in first place, alteration must not be in contravention or provisions of the Act or any amendment done under the Companies Act. It should not attempt to do something which the Act forbids. So if any of the statement or any of the articles which has been mentioned under the article of association is against the law, then hence it won't be valid, it would be void. So the second power of alteration, that is the articles of association is subject to the condition contained in the memorandum. As you are aware, the article of association is subordinate to MOA and MOA is subordinate to Companies Act 2013. I hope the important aspect related to the Companies Act related to article of association has been clear from my side. Thank you.